Hello everyone, and thank you for joining us for today's presentation as part of the Industry Insight webinar series. The topic this time is How to Win the Meet and Confer, sponsored by NextPoint. Speaking today will be Tricia Boguslavsky and Jonathan Papik. Tricia heads up NextPoint's client success team, consulting directly with legal professionals on their ongoing litigation support and technology needs. Prior to joining NextPoint, she spent 14 years overseeing technology operations and creating training and deployment plans for Kroll on Track and Trail Graphics. Jonathan is a partner at Klein Williams Wright Johnson and Oldfather, based in Omaha, Nebraska. His litigation practice focuses on complex commercial matters and cases involving the government. Papik received his law degree from Harvard Law School in 2008, where he also served as executive editor of the Harvard Journal of Law and Public Policy. He is currently admitted to practice in the United States District Court for the District of Nebraska and the United States Courts of Appeals for the 8th Circuit. The Industry Insight webinar series is hosted by the ABA Legal Technology Resource Center. To stay updated on upcoming webinars or view previous videos, visit ambar.org/industryinsight. You can also stay updated on legal technology news through our blog, lawtechnologytoday.org. Thank you all for joining us today, and we'll now begin the webinar.
Thanks, Rose. As Rose said, my name is Tricia Boguslavsky, and I am VP of Client Success at NextPoint. And we're happy to have also Jonathan on our call with us today as we talk to everybody about how at the beginning and early phase of the litigation process, it's really important for clients and law firms to get an understanding of the electronic data involved in their case. And really taking a look at how your meet and confer is more of a plan and how you can set that out as more of a plan during this process, as well as getting a good understanding of, what that data is you're collecting, how are you going to collect that data, and really setting aside some preservation goals in regards to the data. We'll also be getting into some detail about negotiating clawback agreements and just focusing on the cost around the e-discovery process and what things to consider as it relates to the burdens and proportionality. And then lastly, I know that a lot of you have probably heard about, the updates with the federal rules, and we'll be incorporating some of those updates within today's discussion. So as I get started, you may recognize this chart as a modified version of the EDRM e-discovery workflow. And really we're going to be focusing on today the first three phases of the litigation process, which are identification, preservation, and collection. However, I like to show this chart to illustrate all the phases of litigation because really the early phases we are talking about today can affect the success of the later phases of the process. So for example, you see production on here. And one thing to consider is if metadata fields are not determined during the early phases, the productions that you may receive from your opposing counsel may be affected if those metadata fields are not shared. So when we talk to our clients, there can sometimes be a lack of commitment to working out the details around electronic discovery early on in the case. And this could be due to, lack of resources, maybe it's the time in the schedule of the case, or just not knowing where to start. E-discovery competency can help you to really, win or lose your cases, and also really prevent yourself from getting, data dump or overrunning costs on the case. So I'd like to turn it over to Jonathan right now, as he's been recently working on a case in the Southern District of New York, and he's going to talk a little bit about what he has learned from the early e-discovery planning in this case.
Yeah, thanks Tricia. I would echo what Tricia said about there's often a lack of commitment to working out details early in the case, and I think there can be a lot of reasons for that. You have a case that I'm sure we've all had cases that just get started, and completing a Rule 26F report, which we're going to talk about in more detail in this presentation, is just one more box you have to check off as part of a busy practice, and it can be easy to not give that a lot of thought, to not really engage opposing counsel and talk about discovery, and just sort of go with a standard form. But there are some judges in the Southern District of New York, and I think around the country, that are really taking some steps to push parties to engage on e-discovery and other issues as very early in the case. And I think that that's, whether you're obligated to do that as part of the local rules, I think it is to everyone's benefit to do that. It eliminates potential disputes down the road. It eliminates, if you just take standard e-discovery planning and set that down as your Rule 26F report without really taking the time to think about what unique e-discovery issues might arise in the case. When those issues do arise later in the case, you're having to go back to the judge and ask for orders or relief or extensions of deadlines. So I think there's a real benefit to just engaging the other side in a meaningful conversation about a lot of things from the outset. And we'll be talking about a lot of these in more detail, but that could be e-discovery search terms, whether there's going to be a need for a clawback agreement on inadvertently produced privilege documents, how both sides are going to try to achieve proportionality, as that's a real focus under the federal rules as they've been amended to address e-discovery. Talking about things like how many custodians of data are reasonable to be searched, what kind of information those custodians have, what kind of metadata needs to be produced or not produced, how is information stored. And there's a lot of things you can talk about. And the title of this presentation is How to Win the Meet and Confer. And I think how to think about how you win a meet and confer is probably different than how you think about winning a motion to dismiss or a motion for summary judgment, where one side's going to win and one side's going to lose. Really, both sides can come out of a meet and confer as winners if there's a meaningful conversation that is going to drive discovery in a way that keeps down costs, and both sides can get the relevant information so the merits of the case can be decided.
So yes, and as Jonathan mentioned, one of the pieces of setting up your case for success is going to be the Rule 26 F, meet and confer. And it is an obligation under the rules of civil procedure, but we also believe, as he just mentioned, it's also your best opportunity to make the process work in your favor. And typically, it's not a sit-down formalized meeting, but, many clients communicate over email, phone discussions, with details, and they work alongside each other to discuss, how they're going to be setting up their case. This discussion, when you do take the time to identify and understand the data at the beginning of the case, will increase, as we mentioned, the efficiency and reduce the financial responsibility as you continue through the process. So, it is your responsibility to secure the best possible outcome for your clients. And we also believe, if you haven't read the principles of the Sedona Cooperation Proclamation, and I do encourage everyone to read that, this document, which has been endorsed by a number of magistrates and federal judges in rulings, really lays out a model for making the discovery process a collaborative and cooperative process. And it doesn't really mean that you're going to give up the rights or take a non-adversarial stance, but it does mean that all sides are upfront and clear about the data, and that they may be requesting. So this type of information is needed in order to make your case and work together on a plan that best suits the needs of both parties. So we put together, a checklist, and we're again talking about this throughout the presentation, but we do have this Rule 26F checklist, and I think you can actually download this after the presentation too. We put this together in a document, but it's really important up front to get to know your IT's infrastructure. What's their email setup? What sort of data retention policies do they have in place, if any do exist? Drafting your preservation request, which we're going to go over some tips there. As Jonathan mentioned, talking about, with the other parties, what are going to be your key search terms that you want to use for this case? And then determining, like, what are your file formats of how you're going to be producing it, and what sort of metadata or information about your data do you want to exchange with those parties? What's really important and necessary? And then lastly is really negotiating, a clawback agreement in case privileged information does inadvertently get produced. So as we said, the first step is, identifying all your client's data. The Rule 26F states that all documents, electronically stored information in your possession, custody, or control are discoverable. So the questions you ask yourself are, one, who has access to this discoverable information, and also what types of discoverable information are available. So the ways, the who in, who is discoverable is really, who are your custodian? A custodian could be someone, at the client, typically that's, a party to the lawsuit, who has information that's, relevant to the pending litigation. Sometimes they're also called the key persons, as they typically hold the keys to the information necessary to proceed with the litigation. The what is almost any piece of electronic data. We're increasingly seeing the discovery of social media, websites, cloud storage, mobile devices. We just did one this week. And all kinds of data that didn't exist a few years ago, being entered into evidence. So there's a lot to consider when asking the question about what is discoverable. And these are key points to discuss during that meet and confer to assist in the identification process. So, for example, we often, we do see cases with employee email files. Documents collected from company servers, and even data exported from like a purchasing or invoicing software used during the standard course of business. And we've also noticed there's a small number of formats that seem to dominate the world of technology. And one of those formats we often see is called a Microsoft, a PST file. We often get questions from clients of, what is a PST? And a PST is basically a container file, similar to a zip file, that you receive with data. And the PST files are file formats that store messages, calendar invites, and other MS items. So if your client, for instance, has Microsoft Outlook, you will most likely be dealing with PST files. Another consideration when you're looking at, the type of data that you're going to be collecting and identifying is, what type of case is this? For instance, if you're a firm that specializes in employment law, it's useful to know what types of databases are commonly used to track employment records, how data is stored in those, and how to extract that data from those employee softwares. Or we see a lot of construction matters, and you may need the original drawing files for that construction case, such as what are called DWGs that were created in programs like AutoCAD. And these files can often be large in file size when imaging, and you may want to determine the best format for imaging these files. Understanding this all at the beginning, again, will help you to successfully set up your case. So we just talked a lot about your client's data, but what about the other side's infrastructure? And it's also just as important to understand the opposing parties' IT infrastructure to really prevent a data dump of duplicative data from multiple sources. And a meeting with the opposing IT manager gives you the opportunity to figure out what data is important to request, so you're not going back and forth during the discovery process. So Jonathan's going to talk a little bit about how he's put this into practice, maybe not necessarily doing a formal 30B6 deposition, but meeting with IT and other ways.
Yeah, I think there's a variety of ways that might work to accomplish this goal. The slide mentions setting up a 30B6 deposition for the opposing IT manager, where you would identify the topics that would be, kind of the 5 topics listed on the slide here, and you can ask that person under oath and find out where information is stored, how it's stored, and you can then tailor your discovery requests with that information in hand rather than having to sort of broadly ask for everything they have regarding a variety of topics. Some alternatives, I think if you didn't want to do a formal 30B6, just engaging the other side's counsel and saying, this is some information we would like to know. We want to know how your server works, where you store things, how your email works, what are your retention policies, do you have auto-delete functions? And, I think I would start with that, maybe before a 30B6 deposition, and opposing counsel should give you that information. I've also had a case where both sides just got on the phone with opposing counsel and the opposing side's IT person and asked questions, and if the question was asked that the lawyer didn't think the IT manager should answer, they were free to jump in. So I think there's a variety of ways to accomplish this goal, but any one of them ought to give you some information that can help you as you structure your discovery requests.
So once you've determined your custodian's data set, the other side, talk to, like we just said, the IT or someone about the other side's data and what is discoverable, you need to make a reasonable effort towards preservation. And the goal during preservation is to mitigate risk. You want to do the best you can to authenticate the data and to minimize any threats to the integrity of the data. So you want to make sure that it's legally dispensable, reasonable, and proportionate. To preserve your data, you should first notify your custodians. Like we said, schedule client interviews, and then start. We talked about developing a plan. The new Rule 37E, established last December, presents a uniform process and standard, which will resolve the split amongst the circuit courts, availability of the most serious ESI, spoliation, and sanctions. So, it's trying to establish this uniformity amongst the courts, while in addition discouraging any sort of, default practice of saving everything just to avoid sanctions, and to really approach, preservation using proportionality. So, for preservation requests, you should work with your custodians to find the minimum, scope of relevant information, document also that preservation process. And as previously mentioned, starting the process early is always beneficial, so you don't necessarily want to wait until the 26F conferences. And you should also consider preservation as an ongoing process and not just one step. Looking at, how all these steps can be taken, and to allow to help you make more defensible decisions with your case. And preserving everything is not going to be the answer, but taking these steps is going to be what you want to consider. So after you've made these decisions and you're ready, to start collecting this data, there are various routes or ways that you can, you can collect. There's things you should also consider. So for instance, if your client does have an in-house IT department, or maybe they're a smaller technology company and they know what they're doing as it relates to technology, self-collections can be utilized. If you do go this route, make sure you understand their methods as we just discussed for collecting, and ensure that there's documentation about the steps taken during this process. For other, more complex collections, we, see that, a forensically certified expert may be required, because you want them to provide a detailed data analysis as well as the proper chain of custody of computers and hard drives. And if you do go this route, be sure to confirm that the vendor you selected is a certified forensic expert. And then lastly, you do have ways to remotely collect data. And this is also, it's a forensically sound way to collect the data through forensically sound collection tools. So you can do that for, let's say you wanted to collect various types of email or data from someone's hard drive, but you don't need to maybe collect it from, I don't know, hundreds of sources, but you're dealing with a small source set. You can utilize remote collection tools. And then one thing, although I don't want to talk about paper, we still do need to talk about paper at times, and it's important to not forget the paper documents. And we often see clients do need to engage, have someone like a scanning vendor. They can either have the data documents shipped to them or do it on site and make sure that the scanning vendor understands, what file format you need as well as any metadata about that information. So, after you've collected the data and you want to now figure out, what data is actually, relevant. And, we do have ways to cull down and filter down data through early case assessments, or some people call them early data assessment tools, which can provide analytics and reporting to what your data set is before you even begin your review. And you can figure out also what kinds of files you have, the various authors of the data, and other important information regarding the data set that can assist in the reduction and organization for the review. This obviously increases efficiency and can also reduce financial responsibility. I'm actually going to turn over to Jonathan because I think, he talked a little bit about it earlier as far as developing out search terms, but this is where you can also use your search terms, and just talking through a few quick tips in regards to developing search terms.
Yeah, I think if you have a case where the volume of documents is sufficiently large that there's just no way you're going to have eyes-on review of everything in your various custodians' computer and drives and the server, search terms are a reasonable way to identify potentially responsive documents. And I think you just need to be thoughtful about using search terms. I mean, it's kind of like doing searches on Westlaw or LexisNexis. If you use really generic, commonly used terms as your search terms without anything modifying it, you're likely to get, so many documents returned that it really wasn't useful. So being thoughtful about not using too generic a terms is one thing. But really, more than anything, I think it's important to view the use of search terms as an iterative process where you're going to try different search terms and see what the volume is and modify and tweak as necessary. I've worked with Tricia on a couple cases lately where we've used search terms, and she probably gets tired of me saying, well, can we modify this? This is just a little more documents than I think it makes sense to review, or I think there should be more here. So I think viewing it as a process rather than just coming up with search terms and sticking with those is important. The other thing I would say about search terms is there can be a real value to engaging opposing counsel on search terms, both as far as which search terms you're using and which search terms they're using, or if search terms are being used at all. There's a benefit in exchanging those for you so that you can ensure that the search terms the other side is using are reasonable and they're not leaving out something that will likely lead to responsive documents that you want. But it can also be a benefit to you because you can eliminate this. It's harder for the other side to object to some aspect of your production if everybody has agreed on the front end that electronic search terms are going to be used and they had a chance to look at your search terms and they didn't complain about them.
So, we're kind of going to skip ahead to talking about production specifications, but as I mentioned early on and when I showed the e-discovery, the chart, production is at the end, but it's something we should consider, in the early phases. And, what's really important is to talk about, the format that you want to get as far as the documents go from the other side, and make sure you have that ironed out. What data fields you'd like, or metadata information do you want from the other side, and do you want to give, and then how you're going to deliver this information to the other side. How are you guys going to transfer it over? And there's various ways, and we could probably do spend another 15-20 minutes on this. So I know we're getting towards the end of this webinar, and we have a couple more slides, but production and what you're going to do, how you're going to exchange that data is just really important to talk about, at the beginning of the process. And then, oftentimes the production is defined in your ESI protocol. One thing I didn't mention there with the production is we see, the definitions of productions in ESI protocols. And then in addition to, defining, your production formats in ESI protocols, we often do see too, clawback agreements, whether it's, attached as an addendum or if it's included within the ESI protocols. So your clawback agreement can be a supplement to this, and you can include details, around clawbacks. So the Federal Rule of Evidence 502B prevents disclosure from operating as a waiver in 3 circumstances. The disclosure was inadvertent, the holder of the privilege or protected documents, they took reasonable steps to prevent disclosure during this process, and then also they took reasonable steps to rectify the error, and this can all be outlined within your clawback agreement. So some things to just consider, when you're drafting clawback agreements, or goals of that clawback agreement, is to establish that, inadvertent disclosure is not necessarily a waiver, and you can also consider incorporating a clawback into more of a protective order, or like I said, into your ESI protocol. And then how the clawback agreement, defining how it's going to really eliminate disputes about, the reasonable steps, and just establishing procedures within the clawback agreement of how you're going to invoke that clawback agreement. What are the steps you're going to take if, for instance, something does get produced that was privileged? So before we wrap up, though, today, we did want to talk a bit about cost and burden of all the steps, that we just went through, because, it is a process, and how it is important to keep proportionality in mind during all phases of your e-discovery process. So Jonathan's going to talk a little bit about the case he just mentioned earlier in the Southern District in Illinois in the discovery process, and how the judge has put some parameters on the case for the parties.
Yeah, this is a case in the Southern District of New York, and the judge has individual rules and practices on various items, including e-discovery. And the e-discovery rules are really aimed at achieving proportionality. And I know we don't have a lot of time, so I'll just sort of briefly mention them. But the default rule for this judge for request for production is that a party should not be required to search for more than 10 key custodians for documents that was created more than 5 years before the filing of the lawsuit, or for more than 160 hours, including all the time that's required to identify documents, search for it, review it, code it, and produce it. Now, those are default rules that I'm sure that you could go to the court and say, this is about events that happened more than 5 years ago, or here's why we need more than 10 custodians or more than 160 hours. But those kind of default rules, I think, are likely to become more popular as judges try to achieve the elusive goal of proportionality. And I guess I'm not really sure with the 160-hour limit, for example, how you would go about enforcing that. But it is something that's available to you, where if you get very broad discovery requests and you can demonstrate that, well, even if we use search terms on this, it's going to result in a volume of how many thousand documents, and there's just no way this could be done in 160 hours. That's a tool at your disposal for achieving proportionality. So I think that that's a reason to look at the local rules for the judge and court that you're in, but also just to another way to think about proportionality and proposing something to the other side, saying, this is something one judge has recognized as a tool to achieve proportionality. Can we implement that in our case?
So again, a couple of few just to reemphasize those tips of, really just thinking about how you can agree upon key terms with opposing counsel for searching and calling the data, looking at, how are you going to produce this and exchange data, and, what does it make sense to spend the time and money on, for doing that production. And then also, one thing we didn't talk about is just if there are multiple parties, what's the best way to share that data so you're not getting, duplicative data from, third parties and, all these various parties involved in the case. So just a quick recap before, we turn it over for some questions is just, understand early, what you're dealing with as it relates to your data. Identify your relevant custodians. Consider your clawback, and creating a clawback agreement for certain cases. Decide what metadata you want. What information do you want about your documents? Know your client's data format, and also know your opposing counsel's data format, and just be reasonable in your approach. I think how Jonathan put it is that this is just a little bit different than when you think about winning your case when you're writing a brief or going to trial. It's making this be a more collaborative process. And then lastly, if you do need assistance, we have put together a Meet and Confer prep kit, and this prep kit includes some checklists for the Meet and Confer tasks, common production specs we see, and also a worksheet for estimating, page counts for review. And you can download this. It's available at nextpoint.com/meet-confer-prep kit.